Good afternoon. My name is Hae-Sun Kim, advisor of Gangnam Labor Law Firm. Today, with the labor attorney Jung Bong-soo, we will discuss about the Labor Standards Act Article 19, which is the violation of working conditions. So, could you explain the detail about this Article 19?
Yeah. Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. So Article 19 of the Labor Standard, which is the violation of working condition. So when employee have the employment contract with the employer, then some working conditions stipulated in employment contract must be observed or must be implemented. Then also later, if employee realized that company didn't follow the working condition they agreed, then employee can cancel the contract and take a legal claim for damage from not following this working condition. So Article 19 is said employee can take a civil claim or some damage claim to the Labor Commission. So Labor Commission will handle the case and they will judge how much company should compensate for this non-implementation or the violation of this working condition, what they agreed based on employment contract. Yeah.
I see. So, in ordinary cases, it is common that the employer dismiss the employee in many cases, but this is the other way around. Mm-hmm. So I think in case of the employee make a claim, he needs to know about the Labor Standard Act. Is that right?
Yeah, that's right. Yeah, employee they must know the legal right. So when employee neglect to follow what they agreed in working condition, then employee can take a damage claim against the employer through the Labor Commission. So then Labor Commission should support and take care of this claim case as one of the legal cases. So if employer violate the working condition that they agreed in the employment contract, then employer should compensate for damage, also pay back the return expenses for employee. Yeah.
I see. So could you explain in case as a labor attorney, do you have some experience of this violation by the employer to the employee?
Yeah, about a year ago, we helped one employee who was assigned to the Mexico factory. So this Korean the automobile company have an overseas branch in Mexico, and they need some the branch overseas branch manager. So they posted the branch manager position. So they provide some certain working condition like providing good housing, also 5 million won for their the monthly salary. Then when one employee applied for their position and they got the employee passed the exam and he was employed and he was assigned to the Mexican the overseas plan. Then after he was assigned to that location, the Korean new employee realized that there are no place for living decently, so he had to stay in the temporary the housing, like just he can sleep and living very poorly. So also his salary, he expect to have 5 million won in writing, but new contract he was given. That contract was the month's salary was 4 million won. So because of those very different working condition. He could not accept, so he rejected. It is a violation of working condition. So he quit his job and returned to Korea. So in this case, he visited this labor law firm and asked me to take care of his case, quoting like Article 19 of the Labor Standard Act, violation of working conditions. So we represented this employee and take this case to the Labor Commission. So we submit the damage claim to the this Labor Commission, explaining that this employee was supposed to receive 5 million won. Also, he was supposed to have good the housing, but it was very opposite. So new contract provided was a violation of what they agreed in the job posting. So we explained. Then the Labor Commission decided and ruled that company violated Article 19, the violation of working conditions. So Labor Commission forced the employer to pay special damage, the compensation. So it was settled with a mutual agreement. Yeah.
I see. In case of this kind of violation, if it's domestically happened, maybe not so big loss, but in such case, he had to move to Mexico and come back, and it must have been very big damage for his personal condition.
Yes, so Article 19 is a violation of the working conditions, especially Article 17 show the employment contract must be written in writing, must be issued to the employee. So written agreement, written employment agreement is very important because it will solve or it will reduce the potential the conflict because it's already stipulated in writing. So Article 19 explains exactly how employee be responsible when they violate this working condition. Yeah.
I see. This is, I think, is a very important article for the employee and workers. Thank you very much.
Okay, thank you for watching. Bye bye.